Memphis thug cop fails at copsplaining to the judge, a clarification from the condescending lieutenant leadership case in Sandy Springs, Georgia, and a surprising step in the right direction from our good cop of the week, all on this week's episode of The Rebuttal. What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. This is The Rebuttal. This is a place where we do miniature updates on the cases that we've covered in the past and clarify some things that may pop up in the comments section after I publish the video. The first matter on our docket for the day is the Memphis thug cop case we did back in July. If you haven't seen our original coverage for this or any of the other matters that we'll be talking about today, just pause the episode here. You'll be able to go to the video description and see the links to the other content that we're going to be discussing. Then you can work your way back and you'll have all the context and be caught up to speed. But back in July, we did the case of Mario Shaw, who is a Memphis man who basically was involved in some sort of a neighborly dispute with a guy who lived in his neighborhood. The police came over. They wanted to try to ID him for really no reason. And because he told them to get off his property, they basically decided to run up and start beating him up just to show him who the boss was and not to talk back to the cops. Well, it backfired on them, and he ended up filing a lawsuit. And the prosecutor's office in Shelby County, Tennessee, has, of course, been trying to prosecute him for literally just standing on his porch and telling the police to go away and not just taking an ass beating when they decided they wanted to give him one. And so that all came to a head last week, and the charges against him were dismissed. But the reason that I wanted to talk to you about it is because it was a really interesting sort of dynamic that existed between this witness and the prosecutor and the judge. And so we wanted to just let the news give their update, because basically they have everything in this newscast that you would need to know about the case. So without further ado, let's go out and check out ABC 24's update, and then I'll give you a couple thoughts that I have about it after we watch the video. Let's check it out.
New tonight, a Memphis police officer testified in court that he bit a man during an arrest and laughed about it. Take a listen.
Is that one of your bite marks?
That looks like the original. So
Are there more than one?
I don't, you have to ask him that.
Well, I'm asking you. You ought to remember how many times you bit a man.
We've been following this case for weeks. In July 2024, police were called to Mario Shaw's home in Fraser after he had an argument with a neighbor. Minutes after police arrived, Ring video shows officers kicking, hitting, and tasing Shaw in his own front yard. ABC 24's Yvonne Cooper shares what happened when a judge heard this case.
At the time, Mario Shaw faced several charges against those officers, but once a judge saw the video and heard one officer's testimony, the case against Shaw began to fall apart.
You state your name and spell it for the record.
Taiwan Brooks.
Officer Taiwan Brooks was the only witness to testify during this 30-minute hearing. All of the evidence centers around this Ring doorbell footage from Mario Shaw's home.
Get up on my yard.
That's Mr. Shaw, right?
Correct.
Pointing out toward the street. Now, who is this coming up here?
That's me. That would be me.
Attorney John Pritchard, representing Mario Shaw, began by questioning Officer Brooks. For the first 9 minutes, Officer Brooks explained what led up to this violent arrest from his point of view.
We gave him several commands to identify himself, to put his hands behind his back. He refused to do so. He swung on me, he struck me, and then I followed him back, struck him several times. My partner tased him.
Identify yourself. Please.
In the video, you can hear Officer Brooks say, "Identify yourself." But you never hear him ask Shaw to put his hands behind his back. Officer Brooks also fails to mention that 3 seconds later, he ran to Shaw's porch and grabbed him.
Well, is this other stuff we saw here what you do as a police officer?
If you fight me, I'm gonna fight you back, then yes.
At what point in this video are you trying to just simply handcuff him behind his back?
When you saw from the video, I ran up to grab him. He resisted. He threw me to the ground. I got up.
He threw who, where?
If you're looking at the video,
I've watched it 40 times.
watch it 41.
The video shows both men try to stand up. Officer Brooks throws a punch. Shaw falls back down to his knees. Officer Brooks then punches Shaw in the back of the head at least 5 times. Then, his partner, Officer Kevin Shannon, runs up with his taser.
And you're attempting to detain him. Did you bite him?
During the course of the fight, yes.
You bit him.
Yes.
It was police policy to use biting to detain someone.
Now, police policy is to tell you to stop and turn around, and when you resist,
You bite him.
punch the officer.
You
and
bite him.
fight the officer.
Then, Judge Christian R. Johnson weighs in.
That does not look like a normal arrest, sir.
Well, it's a fight.
That is not a conversation with an individual on the porch asking them to step down. That is a person running full speed and tackling another individual.
Officer Brooks answers the judge.
He was trying to go back in the house.
The video shows him just standing there as you charged him and tackled him.
During the hearing, Officer Brooks said the entire interaction was not shown on this Ring doorbell footage, but the state did not submit the officer's body cam videos as evidence. The prosecutor did not cross-examine Officer Brooks, but said this.
Officer believed Mr. Shaw might have been armed, and then during that conversation, when he went to detain him for officer safety, he was struck and thrown on the ground.
Which contradicts the video that I just watched.
But this was not an attempt to detain him. Attempt to beat the shit out of him. That's what it was. And I'm asked about everything that dismissed against Mr. Shaw.
Now, Judge Christian Johnson dismissed all charges against Shaw. Shaw is suing the officers and Police Chief C.J. Davis for up to $300,000. The Memphis Police Department confirmed months ago that arrest was under review within the department. But because of this lawsuit, the department refused to answer more questions. ABC 24 obtained Officer Taiwan Brooks's personnel file. In 2021, Officer Brooks was temporarily relieved of duty after he hit an ATV driver with his police cruiser during a chase. The personnel files describe his actions, quote, intentional and excessive. He was suspended without pay for 20 days. For now, MPD will not comment on the employment status of the officers in this case.
So a couple notes here. First and foremost, this attorney, I don't know him, but his name is John Pritchard. He did an incredible job with this cross-examination. One of the great things that you get from understanding how cops think is that you know as a lawyer how to talk to them in a way that makes them feel comfortable. You can build rapport with them and make them maybe more comfortable than they would be if they thought they should be on the defensive or that you were going to be on the attack. And you can do that with any witness, but specifically cops have a certain way that they speak, that they communicate, a certain sort of common parlance that you can use to communicate with them that makes it seem like you understand how they operate. And obviously that helps if you've been a cop before, but you can also sort of acquire that skill by just being around a long time and talking to a bunch of different cops. And I mean, I'm not saying I'm special, but there are very few of us in the world who have done both jobs. And, you know, I don't know whether Mr. Pritchard is former law enforcement or if the reason he's able to do this is because he's just been around so long, he understands how they think and operate. But what he did here is the same technique that detectives can use to make criminals confess. And the way that you do that is you sort of make them feel like you're basically the same as them. Like, I get it. I get how you feel, man. I probably would have done the same thing. And then once you've established that rapport with them, you can, you know, get them basically to say things that would otherwise shock people because they feel like they're not alone. They're not the only person who feels that way. And so if you're a savvy lawyer, you can use that exact same technique on cross-examination and make them feel comfortable in saying the sort of quiet part out loud and admitting to things that are going to shock the audience and whoever's listening. And that's what he did. It was a brilliant cross. But how about the ego on Officer Taiwan Brooks here? Just no big deal biting a guy, telling lies on the stand that were obviously contradicted by the same video that everybody in the courtroom watched, and then has the audacity to try to tell the judge, you don't get it. And the part where the attorney's like, well, I've probably watched it 40 times. And he goes, well, watch it 41. Just unbelievable how arrogant he is to just sort of dismiss the scrutiny that the judge is laying on him. Oh, this isn't the whole interaction. Trust me, judge, not your lying eyes. But kudos to the judge for dismissing it and seeing through the bullshit. And now Shaw's lawsuit can proceed forward without sort of the disability of the criminal charges hanging over his head. And lastly, shame on the Shelby County District Attorney's Office for even pursuing this case from the beginning. Anyone with a set of eyes and a pulse could see that this was nonsense, and what they should be doing is charging Officer Tywan Brooks for perjuring himself and lying to the judge on the stand, but at a minimum, they should have at least dismissed this case during the initial screening because there was no probable cause to make this case in the first place. Because they chose to pursue it, I'm really glad that John Pritchard made them and their arrogant thug of a witness look like absolute clowns. The next item on the docket is clarification on the Sandy Springs lieutenant leadership case in Georgia. Several of the commenters asked me why I didn't take the opportunity during the video to go through the legal merits of whether the police could, in fact, enter your apartment without a warrant under the circumstances of a shooting in the general vicinity. And I understand the question. It's a fair one, but the answer was there wasn't enough facts for me to make a determination. But I can say that I think that it's doubtful that they would have had what they needed in order to enter the apartment without a warrant pursuant to some adjacent nature or proximity to a crime scene. The controlling case that governs this is a case called Memphis versus Arizona. Memphis was a United States Supreme Court case that was decided in 1978. And in that case, there was an undercover narcotics officer that entered Memphis' apartment during a drug bust and gunfire erupted. The officer was shot and killed, and Memphis was shot and taken to the hospital. After the shooting, there were homicide detectives that conducted a 4-day search of Memphis' apartment without a warrant. What they did was they basically did exactly what happened here at Sandy Springs, except they were inside looking through drawers, photographing things, collecting evidence, and essentially turning the apartment into a crime lab. The state of Arizona took the position that there was a murder scene exception to the warrant requirement, and they argued that once a homicide occurs inside a residence, the gravity of the offense itself would justify a warrantless search for evidence. But the Supreme Court said, no, you're smoking dope yourself. There is no such exception that exists. Even though a homicide occurred and a cop was dead, it does not dispense with the Fourth Amendment protections for people. Once an immediate emergency, like rendering aid or neutralizing a threat, ends, officers have to get a warrant before they can search and seize evidence. And so the key language of the holding was that the court said the seriousness of the offense under investigation does not itself create exigent circumstances. A warrantless search must be strictly circumscribed by the exigencies which justify its initiation. In other words, if you didn't have exigent circumstances to start the search in the first place, then you can't go searching through the house. So there is no murder scene exception. Exigent circumstance entry is limited to the immediate safety, aid, and prevention of evidence destruction, as it always has been. So in Memphis, unlike here, there was a confirmed active homicide scene inside the residence itself. Officers knew a violent felony had occurred in that apartment and that one of their own had been shot. They were already inside lawfully under a pre-existing exigency in order to aid victims and secure safety when they started the multi-day search that the court condemned. The holding wasn't that officers could never enter without a warrant. It was that once the emergency ended, they couldn't treat the home as a standing crime scene for evidence gathering. Now, I realize that in this particular case, the lieutenant has laid out facts that make it look sort of like all they did was go in and check and make sure and then lock it back up. But importantly, there was no confirmed crime scene inside the apartment in Sandy Springs. And so what you need before you can go in and do this protective sweep is lawful presence. And in order to have lawful presence, you have to have an exception to the warrant requirement. You have to have something like exigency or hot pursuit or consent. So the assault giving rise to this circumstance occurred outside and nowhere close to this apartment. The supposed connection that lieutenant leadership is trying to make here to this residence unit came from some vague, ambiguous statement by somebody who might be a friend or a brother and had no direct connection, no blood, no screams, no gunfire, or signs of distress coming from that unit. In fact, the guy said he was inside and then left and had no idea any of this was going on. And so the thing that distinguishes this from Mincy is that in Mincy, exigency already existed briefly and then expired. Here, we have nothing to justify the exigency or any other exception to the warrant requirement. In order to legally justify a warrantless home entry, the officers needed specific articulable facts creating an objectively reasonable belief that someone inside was seriously injured or in immediate danger. None of that existed here, because had they had any contact with anybody inside that apartment, they would have known that he was in there and didn't know anything was going on. Or they could have had hot pursuit, fresh pursuit. They'd need to be actively chasing a known suspect who had just entered that apartment, or somebody that they would have seen or relied upon told them that somebody entered that apartment, or they could have seen it themselves. They weren't doing that. They didn't even know who the shooter was. In fact, they didn't even learn until later that there was no shooting of a person. A third thing that could have maybe justified it was if they had probable cause. If there was probable cause that the apartment itself was evidence of a crime and waiting for a warrant would risk destruction of evidence or danger to life, then maybe they could enter. But again, they had no probable cause. They had no connective tissue between the assault that they hadn't even classified yet as a shooting, or that they had improperly classified as a shooting that was just a regular assault, that connected that crime to this apartment. All they had was a hunch and speculation, and we know that that's not enough. Or they could have had consent, but they obviously didn't have that because they got the homeowner outside questioning what they were doing. Or if they were lawfully present in the first place, they could have done a protective sweep. But of course, they always think they can do a protective sweep simply because they exist and they want to sweep. But that's not how protective sweeps work. Protective sweeps are attached to search incident to lawful arrest or lawful presence. They can't just be in the abstract, I'm going to go do a protective sweep because I think that it would be safer. That's not how they work. They were outside. They can't bootstrap a sweep into a lawful entry. And that's what they were trying to do. And then they basically were trying to browbeat him into accepting their unreasonable explanation for it. So based on what I know about this case, they had absolutely zero justification for doing what they did. But of course, you can't tell them that because they won't even listen to you ask questions without acting like dickheads like they did with this guy. So in order for them to have actually justified the entry of this home, for it to be defensible under the emergency aid exception or exigency or anything like that, they need at least a reliable witness, not a vague acquaintance, but specifically someone stating that they observed a suspect or a wounded person run into that apartment, someone who was reliable and credible. Or they would have needed some sort of audible or visible indicators of distress, like somebody saying, help me, or shouting, or a blood trail, or movement through the blinds. They would need something immediately articulable that would basically have created an objectively reasonable concern that something was happening so quickly that they didn't have time to get a warrant because it would endanger life or endanger the integrity of evidence. And then they would be able to create the bridge between that hunch that they had and then this short limited sweep to make sure that there were no active threats or victims. And then they would have to lock it back up and do what they, according to the lieutenant, did after the fact. But lieutenant leadership here missed what the legal definition of exigency is, because the only definition he knows is because I said so. And that's why we have the problems we have with policing in America. But that's the reason I didn't go into a lot of detail on the legal stuff, because I put my email address up on the screen and asked for the person in the video to reach out to me or somebody that knew him. And I thought maybe I'll do an update later when I get more facts, because I didn't feel like I could make a proper analysis. But come to think of it, maybe if leadership should have taken my lead and waited for more information before they decided to bypass the Constitution, we wouldn't be here and we wouldn't have to lean on lieutenant leadership's explanation of because I said so. But it remains to be seen whether this person will reach out to me or whether I'll get some more information. If I do, I'll do a full update. The third and final item on the docket is the Good Cop of the Week, and this one might surprise you. So if you don't want to be watching Good Cop of the Week, now would be the time to fast forward through this segment, because I'm going to give props to a chief of police from Colorado. This week's Good Cop of the Week goes to Chief of Police David Jackson from the Englewood, Colorado Police Department. Now, I'm not going to go into a lot of detail on this case for the purposes of awarding Good Cop of the Week, because I intend to do a full video on it later in the week. But here is the sort of quick and dirty of what happened. and why he's Southern Draw Law's Good Cop of the Week. One of the officers from Inglewood, Ryan Vicina, stopped a guy for running a stop sign. Vicina almost immediately escalated the encounter, tased the driver who was being, questioning him, but he was being compliant. He was just sitting in the driver's seat of the vehicle. He tased him, and then in the process of arresting the driver, Vicina used a chokehold on him, what the chief referred to as a neck encirclement, which is essentially a choke that is expressly prohibited by Colorado law, and as such is not in line with policy and training. Now, here's where the chief really impressed me. In a world where cops cover for each other left and right, law enforcement leadership routinely doubles down on stupidity, and seemingly no one ever gets held accountable. And if they do, it takes forever and a day. From October 8th, when this happened, until November 4th, when the chief gave the press conference, the chief had reviewed the initial complaint, fired the police officer. The district attorney had been made aware of it, had dismissed the charges against the driver, and had charged this officer with multiple crimes, all in a span of less than a month.
I have a few remarks and then happy to take questions. When we were made aware of this incident and reviewed the body camera footage, the case was immediately referred to the Colorado Bureau of Investigation that same day. The internal affairs detective who viewed the video found it concerning and immediately alerted command staff, which shows that we have a strong culture of accountability in reporting misconduct. An internal affairs detective was reassigned from all other duties to solely focus on this matter. The officer was placed on administrative leave and never worked another shift for the Inglewood Police Department. He is no longer a city employee. The officer was employed by the Inglewood Police Department from November of 2024 until October of 2025. The Inglewood Police Department has fully cooperated and collaborated with the CBI and the District Attorney's Office throughout this investigation to ensure an independent and thorough review. The investigation was sent to an unbiased third-party law enforcement agency because transparency and fairness are critical. The Inglewood Police Department will continue to support the criminal process and provide any assistance requested by the CBI or the district attorney. We are implementing adjustments to our scheduling system to ensure closer supervision and greater accountability. Additional training will also be provided to reinforce expectations around de-escalation, communication, and lawful use of force. After the murder of George Floyd in 2020, the city of Inglewood undertook one of the first police reform initiatives in the state with a resident task force recommending 34 accountability measures, focusing on improving community interactions and de-escalation. This type of conduct is a stain on the profession and is not reflective of the Inglewood Police Department or the people who serve our community with honor. Our community expects professionalism and compassion with those who wear our badge, and that expectation will not change.
Now, that, ladies and gentlemen, is, I'll admit, leadership that we should be able to expect as a bare minimum, but it's never seen in law enforcement agencies. Your people learn what they can get away with by watching how you react to what they do. And I hope that the men and women of Inglewood, Colorado know that they can't do this kind of stuff without consequences. Also, kudos to the district attorney for Arapahoe County for charging this officer so quickly and making sure that he couldn't do this to anyone else. He'd only been employed for like less than a year. He was still on probation, so that made it really easy for the chief to just cut ties with him and move the police department forward without having to worry about him. So really great job all around. As I mentioned, I'll be doing a more long-form review of this case later with the body cam as well as the legal analysis and a couple points about how Inglewood, Colorado might make for a good case study moving forward because of some of the things they've chosen to do in the way of reforming their department in conjunction with civilian oversight boards. Anyway, that's the rebuttal for the week. Hopefully you guys got something out of it. I appreciate you guys watching the rebuttal. And I'd like to introduce a new concept that I'm working towards. I'm going to start doing sort of like a daily reaction to some stuff that I see. A lot of times people will ask me what I think about what happened to Lackluster, or ask me what I think about one particular thing. And maybe it's not a piece of information that is really worthy of doing like a 15 or 20 minute video, but it's something that I could just give a few thoughts on in 5 to 8 minutes. And so I'm thinking about doing a piece of maybe daily content or every other day that's sort of me challenging certain things without actually going into a full breakdown of what happened. So I'll see how you guys respond to that. Look for that in the next couple weeks. I'm going to be starting to do some, it won't be real short form content because it'll be over 3 minutes, but it'll be shorter than what I normally do. So we'll see how that works and whether or not you guys enjoy watching it. Anyway, I'd like to invite you to follow us and check us out on all the socials. You can use your camera phone to scan the QR code on your screen. That'll take you to the Linktree site where you can check out the YouTube channel, the Facebook, TikTok, Substack. You can join on a paid tier of Substack if you want to, but it's only for people who want to support the channel monetarily. I don't put anything on these platforms that people have to pay for. If you don't want to follow us to other platforms, but you'd like to support monetarily, I'll leave my Venmo and PayPal links both here on the screen as well as in the description. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.